Hello everyone. Welcome to A-Level Law Help. In this video we're going to look at the crime of theft. Now this is for AQA courses, but is also relevant to other courses. Let's begin. Theft is defined in the Theft Act 1968. A person is guilty of theft if he dishonestly appropriates property belonging to another with the intention of permanently depriving the other of it. Now this may seem complicated, but let's break it down. To help you grasp a basic understanding, let's first take a look at the 6 sections which theft is comprised of. Section 1 has covered our definition. Section 2 covers dishonesty, one of our mens rea elements. Our actus reus elements are made up of Section 3 appropriates, Section 4 property, and Section 5 belonging to another. And rounding off our mens rea, we have Section 6 with the intention to permanently deprive. Although I advise you make your own notes. There will be a link to some model notes in the description. Feel free to use them. We will be starting with the actus reus. Section 3 states, an appropriation is any assumption by a person of the rights of an owner. This means D only has to assume one of the rights of the owner. In the case of Morris, D switched price labels in a shop, and by doing this, he had assumed the rights of the owner. He did not actually need to take the objects for this to be so. I have displayed some of the rights of the owner on screen. Note, there are more, but these are the most likely to appear in an exam. Under S3. Where property is acquired innocently, it can later be appropriated by D, keeping it or dealing with it as if they were the owner. So if something is taken by mistake, it can later be appropriated by the defendant selling it, keeping it, or disposing of it once he has realized his mistake. It was held in Gomez. There can be an appropriation even if the owner consented to the property being taken. In Gomez, an employee persuaded his manager to accept 2 stolen checks from his friend. The checks had no value, and even though the manager consented to accepting the checks and the property being taken, this was still an appropriation. In Hinks it was held. There can be an appropriation even if the owner of the property has made a legal gift to D. In Hinks, there was a man with a very low IQ. He made gifts to a woman of £60,000 and other valuables. It did not matter these were legal gifts. It was still an appropriation. Let's move on to our property element. Section 4. Subsection 1 states that property is money and all other property, real or personal, including things in action and other intangible property. Money is coins and bank notes. Real property means land and buildings and can only be stolen under Section 4, subsection 2 if D severs something from the land. Or D is a tenant and removes something which is a fixture of his rented accommodation. Under Section 4, subsection 3, picking mushrooms, flowers, fruit or foliage growing on wild land belonging to another is theft of property if it is taken for commercial purposes. Personal property is the most likely to appear in an exam and covers all movable items such as a phone or wallet. Under Section 4, subsection 4, wild creatures are not personal property unless they have been tamed or are ordinarily kept in captivity. A thing in action is a right which can be enforced by a court action. These include checks, money in a bank account and tickets. Intangible property is property with no physical existence. However, there are some exceptions. It was held in Oxford v. Moss that confidential information is not property for the purposes of theft. Under Section 4, subsection 1, electricity is not property for the purposes of theft. Now, we are covering belonging to another. Under Section 5, subsection 1, property shall be regarded as belonging to any person having possession or control of it, or having in it any proprietary right or interest. Essentially, a proprietary right means they own it. It is actually possible to steal your own property if someone else has possession or control of it. In Turner, D was a man who took his car to a mechanic's to get it repaired. D then used a spare key and took his car back without paying for the repairs. D was guilty of theft as the car was under the garage's possession or control and so belonged to another. Under Section 5, subsection 3, where property has been given to the defendant to be dealt with in a particular way, and that is not done, there can be theft as the property is regarded as belonging to the giver. Under Section 5, subsection 4, if D receives property by mistake, they are obliged to make restoration. So, for example, if you're overpaid by an employer, you must give the money back. Where property has been abandoned, it does not belong to another. The more expensive an item is, the less likely it's been abandoned. Let's move on to the mens rea of theft. This is made up of dishonesty and an intention to permanently deprive. Under Section 2, we are not told what is meant by dishonesty, but there are 3 situations which are made clear not to be dishonest. The first being that D believes he has in law the right to deprive the other of the property on behalf of himself or someone else. The second is where D believes he would have the other's consent. If the other knew of the appropriation and the circumstance of it, and finally, where D believes the person to whom the property belongs cannot be discovered by taking reasonable steps. These don't have to be true, but D's belief in them must be genuine. Where Section 2 does not apply, the test for dishonesty from the case of Ivy is used. Bearing in mind what D knew or believed the facts to be, was D's conduct dishonest by the standards of ordinary decent people? Finally, our last mens rea element is the intention to permanently deprive. In Lavender, it was held D will be regarded as having an intention to permanently deprive, where although he does not mean for V to permanently lose the property itself, D does have the intention to treat it as his own to dispose of, regardless of V's rights. In Vellamil, D took banknotes from a safe intending to replace it with money of the same amount. However, he was still convicted, as he had the intention to permanently deprive the company of the actual banknotes. Normally, borrowing property is not theft, however it can be where it is in the circumstances equivalent to an outright taking or disposal. In Lloyd D worked in a cinema and allowed others to make copies of the film. D then returned the films. He was not guilty of theft, as his intention was not to return the films in such a changed state that all their goodness, virtue, or practical value had gone. In Isom, D picked up a handbag, searched it, and then put it back without taking anything. His conditional intention to permanently deprive was held not to be sufficient for the crime of theft. Okay, that is all for theft. Thank you for watching. Like the video to save it to watch again. Please also consider subscribing if you want more A-level law content. See you next time.